Assalamualaikum warahmatullahi wabarakatuh. My name is Wan Sufia Hanin binti Muhammad Razali. My metri number is 047447 and I am from Group A. For the question of the concept of non-nationals and the scope of international protection afforded by international law toward this kind of people, basically everyone knows what is the meaning of national. National or citizens are the person who have been recognized by a state his citizenship. It can be acquired by being born in the country as under the principle of jus soli, or being born to a parent who is citizens of the country as under the principle of jus sanguinis. Meanwhile, the non-national is a person who has not been recognized by the state as its citizen, but still these persons have their own rights and need to be protected. But nearly all these non-citizen people had faced massive discrimination and biased treatment from the citizens and also from the government of the state itself. The discrimination usually on the racism, on the sexism, language barriers, unfamiliar custom, and many more. Because of this discrimination, the rights of the non-citizens had been denied. There are several international laws existed to provide the international protection to non-citizens. As based on international human rights law, everyone should enjoy all the human rights without discrimination. The International Covenant on Civil and Political Rights had stated the general principle of equality related to non-citizens. According to Article 2, Clause 1, the state party should respect and ensure all individuals within its territory live without distinction of any kind. For example, on the religion or on the race, on the skin color, and many more. Meanwhile, Article 26 had stated that all persons are equal before law and entitled without discrimination and guaranteed the equality of life. Next, based on International Convention on the Elimination of All Forms of Racial Discrimination, Article 1 had stated regarding the discrimination, make sure the non-citizen enjoy equal protection and recognition, and guarantee the equal enjoyment on both national and non-national. In other words, this article focuses on the fair treatment of both citizen and non-citizen. Next, the International Covenant on Economic, Social and Cultural Rights also had stated regarding the right of non-national. Article 2, Clause 2 had declared that the state parties have to guarantee the right of the non-citizens without any discrimination, but the developing countries may determine to what extent they would guarantee the rights to non-citizens. But actually, the main body that responsible to provide the human rights on non-citizen is on the state and the national constitution itself. However, there are countries that clearly stated that no recognition of the right of the non-citizen. For example, under the constitution of Vietnam, it had guarantees the human rights only to citizens. And also, under the Constitution of Nigeria, it had distinguished between the rights granted to persons who obtain their citizenship by birth and other citizens. Merely mentioning the general principle of non-discrimination in the Constitution is not a sufficient response to the equality requirements of human rights law. Thus, states are the body that are obliged to have in place effective legislation to fight against all forms of discrimination. So, as for conclusion, this person has their own right to be protected, such as right to life, right to liberty, right to security, protection from refoulement, and many more. The non-citizens are also human. They deserve equal treatment. The only thing that differed them is a legal document. Thus, it is the obligation of international law of human rights to protect these people and with the cooperation from the state by implementation of the law. That's all from me. Thank you.